And good day and welcome to the Employment Law Show. John Scholes, Lior Samfiru. Here we talk about your workplace rights and everything that has to do with the place you spend thousands upon thousands upon thousands of hours of your life. So it's pretty important stuff, right? Yeah, tens of thousands. We did the math once. It's an unbelievable number when you figure how long you're in the workforce. But anyway, I digress. To reach out anytime when we're not on the air as well, 1-855-821-5900, help at EMPLOYMENTLAWYER.ca. And if you just go to simply EMPLOYMENTLAWYER.ca, the website, you will find a resource to find past shows and our radio show as well. So that's all coming up, some phone calls from those radio shows in just a few minutes here. But we always start, my friend, with the week that was. How has it been?
The way it's always been. On the phone a lot, on email a lot, answering a lot of questions about workplace rights, about employment law, about problems that individuals are facing with their job, in their job. Maybe they just lost it, or maybe they're concerned about losing it. And you know, John, there's a lot of things that impact us, but I don't know that there's anything that can impact us more than if things don't go well in our job. Yep. You know, we spend, as you said, so much time there. It's such an essential part of our identity that if something goes wrong, if we lose the job, it really is a big deal. But the good news is that the law, employment law, is actually quite good in protecting employee rights, giving employee rights employees a lot of entitlements. But the law can't help you unless you know what it is, unless you give it that opportunity. That's what this show is all about, to educate and inform. So hopefully you will take that out of the show, or if you want to just talk to me privately, not a problem. We'll give you my information. You can call and email like many, many people do, and I can solve your problem, or at least hopefully make you feel better about your situation. About a week there was a situation that came across my desk. You know, John, this is a not new one. We've talked about similar situations in the past. Makes me shake my head always. So this person worked for an auto manufacturer, which will remain nameless for the purposes of this chat. And she had taken a number of sick days, and she had some medical conditions. She had to have a little minor surgery, and there was a bit of complications from that surgery. So over a span of a year, she ended up taking about 15 or 18 sick days. Now, this company had a policy of 5 sick days. You get 5 paid sick days.
Gotcha.
And after she used up their 5, they said, well, you're done sick days. Don't take any more sick days. Well, she did because she was sick, and after the first or second sick day, over and above the 5 days, she got a warning. They said, well, no, you can't do that. We're warning you. That's going to be something that we'll have to discipline you for. Well, again, she had a little minor surgery. She had to take a day off here and there. And eventually, she gets called into a meeting, handed a piece of paper. We've told you that you're taking too many sick days. It's not been approved. You've used up your 5. Now you're at 15 days. So we're letting you go for cause. Yeah. And extremely upset, she calls me. And her question was, which is exactly the right question, is, what was I supposed to do? She was sick. She couldn't work. It's not like she had a situation where she was sitting at home, doing something else, or playing golf or whatever it is. She was trying to get better, trying to get healthy. So here's the thing, John. You can take as many days as you need to if you're sick. As long as it's legitimate, you can take those days. It has nothing to do with how many sick days the company provides. Now, paid sick days, all it means is you're going to get paid by the company. So a company may say, you can take 20 sick days or whatever, we're only going to pay you for 5 of them. Okay, but that doesn't mean you can't be off longer. And my question is very simple to a company that does this. You're disciplining her. What are you trying to accomplish by disciplining her? Well, that'll teach you a lesson not to be sick. Well, what are you trying to do here? What behavior you're trying to improve? It makes no sense whatsoever. So this is a wrongful dismissal if there ever was one. So I wanted to remind everyone, employees and employers too, if there's a sick day policy, that's fine, but that does not limit the number of days you can actually be sick, because you don't control that. The company doesn't control that. If you need to be off work, as long as you have a doctor backing you up, and an employer is allowed to ask for a doctor's note, that's okay. As long as you have a doctor backing you up, you could be off as long as you need to. Maybe it's 2 days a year. Maybe you need this year 20 days. You had a particularly bad year, you got sick or had some injuries, what have you. You can be off. You cannot be let go or disciplined because you are sick. It's absurd. I've seen it happen. And in this particular case, with this particular lady with the auto manufacturer, I'm going to help her get her full compensation.
Again, contact 1-855-821-5900, help at EMPLOYMENTLAWYER.ca, or simply the website EMPLOYMENTLAWYER.ca. We'll lead you to our radio shows where you can catch those, listen to past shows as well. We always play the phone calls from those shows on here, and we talk about them. First call for today is coming up right now.
I work for a retail company, a large one, and I've just been hearing things. I'm just curious if it's actually true or not. Say, for example, there is a manager that's been with the company for, say, 20 years. Instead of terminating their employment and paying them out to save money, I've heard that they will give them notice to let them go, say, like 9-10 months, your job will no longer be available, and they don't have to pay them out. Does that happen?
It's a great question, and we've talked about before what we call working notice.
Yeah.
So when a company pays severance or has to pay severance, they have two options. They can actually pay severance. You're gone today and we're going to pay you severance. Or they can give, instead of that severance, they can give notice, advance notice. Now, as long as a company gives sufficient notice,
Gotcha.
they may not owe severance. So let's use an example. Let's say based on someone's age, position, and length of employment, they're owed 12 months severance. So one way the employer can meet its obligations is to say, you're gone today and we're going to pay you for 12 months. No problem. The second option is they can simply say, we're telling you today that your job ends in 12 months. We're giving you notice, working notice for 12 months. And in that situation, the employee then may not be owed anything at the end of that 12-month period. Now, obviously, all things being equal, I think an employee would rather get severance than get paid by way of notice. But the reality is that the employer does have a choice to make. Here's the key, though. The fact that you got notice may not mean that that's enough notice. In my experience, most of the time when an employer provides notice, advance notice of termination, they have not provided enough notice, which means at the end of employment, the employer has to make up the difference by way of severance. So using my 12-month example, if in that 12-month example, the employer gave 7 months notice, well, they would have to pay the difference, 5 months pay at the end of that. They'd have to pay that by way of severance. So if your employment has been terminated, whether you're gone today or you've got notice of termination in the future, you have to reach out. You have to call me. You can also go to pocketemploymentlawyer.ca. We'll talk about that in a couple of minutes because you still may be owed more than what you've been provided.
Is there an advantage or disadvantage for either the employer or the employer by whether they just pay you out or pay continuance or have you stick around and work for the entire time?
Listen, from an employer standpoint, I can see, hey, if we have to pay you, may as well get something in return. You know, if I have to pay you for 12 months, may as well have you work for 12 months. The problem, of course, for an employer, they may think, well, that employee may not be very productive, or they may be talking to other people, and they may kind of cause a bit of an uncomfortable work environment.
Sure.
Which is why a lot of the times employers don't like giving working notice, certainly not extended working notice, but they can. For an employee, I haven't yet met an employee that would rather have working notice than severance. I guess it's possible. So either way, it is legal so long as you got enough notice.
Okay, is there any bargaining power? An employee going, man, I got to work here under these conditions. Everyone knows I got sacked, but I got to hang around here for another year. How about we do 6 and 6? Like, can you do that?
It's always negotiable.
Okay.
And by the way, there's no downside in asking.
Right.
So employer told me I'm going to work for the next 12 months. It's not going to be comfortable. How about I leave before and you pay me this amount? Always can negotiate. The worst thing that can happen is the company says no, but before you actually try to negotiate, I want you to reach out to me so we can talk about what would make sense to negotiate, how to go about doing that. It's always negotiable.
You mentioned it, pocketemploymentlawyer.ca. What a wonderful website. It's new and it's really gaining momentum. Tell me about it.
So I'm on TV right now. Well, what do you do when I'm off TV and maybe it's the weekend and I'm not in my office? What do you do if you have a question? Very simple. I'm with you all the time. Pocketemploymentlawyer.ca is like having a little version of me, but just as knowledgeable, with you in your pocket. You go to pocketemploymentlawyer.ca and you find out a number of things about your rights. If you want to calculate your severance, for example, you lost your job, you want to know how much you're actually owed, and by the way, it's a lot more than you've been offered, I guarantee you, you go to pocketemploymentlawyer.ca, first place you go to. But maybe it's a situation where you want to know if you've been constructively dismissed. They've implemented some changes. Is that a constructive dismissal? You go to pocketemploymentlawyer.ca, answer a few questions, and find out in your specific situation if that is a constructive dismissal. Maybe you've wondered if you're an employee or an independent contractor. Maybe you've wondered if your case constitutes harassment or discrimination. Maybe you've wondered if your insurance company was right to cut you off disability benefits. All these things you can find out for yourself on pocketemploymentlawyer.ca. It's free. It's anonymous. It's easy to use. You don't have to put in your information. You couldn't put a credit card number there if you tried. It's there to be a resource for you to help answer your questions, to find out more about your legal rights. So before you call an employment lawyer, you already have one. pocketemploymentlawyer.ca.
Again, like we do every week, it's good to take it out for a spin by example. And from pocketemploymentlawyer.ca, I'll read you this. As I'm 55 and have been an office administrator for 11 years. The company has seen a drop in profits the last few quarters and now want to put me on a 10-week temporary layoff. My contract doesn't say they can do this. Do I have grounds for severance? If I accept this layoff, will my years of service reset when I return to work? That's an interesting question.
It's a really interesting question. And here's the key, and she's absolutely right, that if your employment agreement doesn't give the company the right to lay you off temporarily, a temporary layoff is illegal. And your employer does not have a right to lay you off temporarily, because if they do, that's considered a wrongful dismissal. And some individuals are going to watch this now and be very confused, because a lot of people believe I can be laid off temporarily. No, if you're not unionized, a temporary layoff in most situations is a termination, or at least it gives you the right to treat that as a termination and get your severance. It's very simple. And no, if you come back, your service doesn't get reset. But the problem with coming back and allowing the temporary layoff to happen is you've given the company the right to do it again. And that's the key. So you didn't want to be laid off temporarily, but you decided to do it, and they called you back, you came back. By doing that, the next time they lay you off temporarily, you cannot do anything about it. So I always say, when it comes to temporary layoff, you want to stand up for your rights. You want to treat that as a termination and get your severance. So the next question is, well, how much severance?
Right.
So let's take, as you said, the pocketemploymentlawyer.ca for a spin. Let's see how much severance this person is owed. So you see on the screen, she's an office administrator there for 11 years at the age of 55. She wasn't paid severance because the company just supposedly laid her off temporarily. Well, severance calculator, as part of the pocketemploymentlawyer.ca website, correctly assesses her as being owed right around 10 months' pay. 10 months' pay, depending on how much income she's earning, obviously that's going to be tens of thousands of dollars. So that's how easy it is to use pocketemploymentlawyer.ca. Check it out for yourself. And remember, a temporary layoff in most situations is illegal. In fact, it's a termination.
It's funny when you drill down into it, we've mentioned this before, if you were to say somebody, and I'm going to give you a 50% pay cut for 6 weeks, they're going to say, no, you're not. Oh, temporary layoff is a 100% pay cut.
It's a 100% pay cut for an undetermined period of time. It could be months and months. No. So anytime you're looking at a 100% pay cut, frankly, if you're looking at a 10% pay cut, that is a constructive dismissal. That's a termination. That's not something your employer is allowed to do. If they do that, or if they just reduce your pay by less than that, not an issue. You have a right to treat that as a constructive dismissal. Call me or simply go to pocketemploymentlawyer.ca.
All right, coming up here, the rights of older employees in an aging workforce. Don't say it. You're looking at my beard. I know it. Don't even go there. 1-855-821-5900 and help at employmentlawyer.ca. Lots more Employment Law Show is on the way. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Welcome back to the Employment Law Show. John Scholes and Lior Samfiru. We're going to get to this now, the segment of the show where we throw a bunch of talking points at you. I know you'll want to go into some depth about these. This one today is rights of older employees in an aging workforce. By the way, you want to reach out anytime, 1-855-821-5900, help at employmentlawyer.ca. First one is this. My friend says, can an employer fire an older employee because of their age?
So right off the bat, I think we start with probably the big one, and that is, and hopefully this is not going to be shocking to anyone, employees or employers, you cannot be let go or disciplined in any way because of your age. That would be age discrimination. We have human rights laws in this province, in this country, protecting employees and making sure that you cannot be mistreated by your employer because of your age. That means you cannot be told, well, you've reached a certain age, you're out of here. Right. You cannot be told, hey, you're 65, the door is that way. We used to have mandatory retirement in this province. We do not have that anymore. It was gone, I don't know, 13, 14, 15 years ago now. And because of that, you can work as long as you want. And I spoke with a gentleman earlier this week, it was 79. You're right, we were talking about him. Yep. 79 years old working, good for him. I hope I'm working at 79. But the reality is you cannot be let go because of your age. And if you do, of course you're owed severance, but forget about that for a second. That could be a serious and a very important human rights violation. You can't let that happen. And employers, if you're listening, of course, remember, age is not a factor that should come into consideration when you're deciding whether you let someone go. If it is a factor, you're going to find yourself on the wrong end of a human rights violation.
Okay, so now I'm an employer. I've got that point now. I've got to keep this guy on as long as he wants to keep working. But because of his age, maybe he's starting to become a little less productive. Do I have any options? Discipline, termination? What can I do about it?
So an employer should expect that an employee is productive and does the job that he or she is paid for. That is absolutely fair. And in some situations, if an employee is becoming less productive, well, an employer can't just ignore that. So first of all, you want to do is understand why they're being less productive. Is it a health issue? Is it an age issue? Is it something else? Maybe they're just not working hard. I don't know. But if you find out that there's age-related or potentially health-related, you have to consider accommodation. So if because of your age, you can't do your job the way you used to, an employer does have to provide accommodation. That may mean providing some assistance. That may mean maybe changing your hours. It may also mean putting you in a different role that you're better suited for. And that's okay. So that duty to accommodate is a very important one, and it gets triggered. What you cannot do is you can't say, well, you're not as productive. That's not what we're paying you, sir, out you go. Now, if the employee is simply slacking off, not working hard, you may be able to discipline them, but you cannot jump to discipline just because the employee is not being as productive.
You said change their job, so if it's a case where I can no longer handle my warehouse job because of my age, you got to get me into the office, can I adjust my pay?
So if the only way to accommodate you is in a different role, and that's the only way you can work, and that role pays you less, or that role pays less, then your employer is allowed to reduce the pay, because it's not the employer deciding to change your role, it's the circumstances, your age, your health, that impacts it. So yes, if you're being accommodated in a different role, you could potentially be paid a different wage.
We're talking about dealing with the aging employees in the workforce. The next point is, I'll take it to the point of the employee. Now I'm the aging employee. I realize I'm starting to get a little slower. I can't handle the job. Yeah. Should I? It's easy to sit with a microphone.
Easy. Yeah.
For now. Should they approach their employer? They might be a little bashful to do so for repercussions, right?
Yeah, and I say always, if you're in a situation where there's something going on that's going to impact your ability to do your job, maybe it's your age, your health, there's something else, you should tell your employer. You should be upfront, tell them what it is, tell them what you're doing about it, and also tell them what the employer can do to help you. The problem is if you don't tell your employer about it, if you simply hope that they won't notice, guess what? They'll notice. And they may assume the worst. They may assume that you're just not working hard enough. So if your age is now impacting you, first of all, you may be able to do better in a different role. It's okay to ask your employer for accommodation. But either way, if there's something going on, maybe because of your age you're dealing with a health issue, maybe you're just not as strong or as fast as you used to be, tell your employer that you're struggling. Make sure that they know, because once you tell them, you have this dome of protection around you. They have to accommodate you. They can't fire you. They can't say they didn't know. So it's always a good idea to be upfront with your employer.
Again, questions outside of the show, 1-855-821-5900, help@employmentlawyer.ca. We're talking about an aging workforce and how to deal with it as an employer and an employee. I know this, I remember this distinctly one time we were talking to a radio show. You had an employer who was slowly leaving pamphlets about, retirement homes in Florida. Maybe you might want to have a look. Can they make that suggestion? Can you say to an older employer, you're a little long in the tooth there, Charlie. Maybe it's about time you play a little more golf. It's
absolutely a true scenario. Yeah. It was pamphlets and brochures and, So there's a line that an employer cannot cross. It's one thing to say, hey, I know you had your 65th birthday. What are your plans? That's okay, because an employer needs to know, if you're leaving, I need to plan accordingly. Or have you thought when you want to retire? That's a legitimate question. But if it crosses to the level of, being pushy, suggesting that they should retire, telling them that maybe they don't belong there anymore. If you cross that line, it becomes harassment, it becomes a human rights violation. If you make it clear to someone that you don't want them there, you just hope that they leave because of their age, that is age discrimination. So my advice to employers generally is stay away from that. It's one thing to ask the employee, hey, what are your plans? That's okay, because as an employer, you need to plan accordingly. Do you hire someone? Do you not? But beyond that, don't do it. And if your employer is dropping hints subtly or not so subtly, that's not something that they should be doing. If you're facing that, that could be harassment. You want to reach out to me. We should have that discussion as to whether or not your employer has crossed the line.
The last question is always the money question, right? How was severance calculated for that older employee?
So here's the thing. Age is always a factor in deciding how much severance. Age, position, and length of employment are the main factors. Therefore, the longer you work and the older you are, the more severance you're owed. And it's assumed that if you're older, it may be more difficult for you to find another job. Maybe you won't be hired as quickly because of your age. Therefore, that means you're going to get more severance. So an older employee, an employee, in their 50s and beyond, may get a lot more severance just because of their age than someone that's younger than they are. So remember, age is a factor, and you may be owed more severance. That's why it's so important to get advice if you lose your job. You can call me. You can email me. You can also go to pocketemploymentlawyer.ca, because your entitlements, especially as an older employee, can be even more significant than they would otherwise be.
Again, employmentlawyer.ca, that is your online resource to find past shows of this nature or the radio show. We pull the phone calls from the show, the radio show, and we talk about them here. Phone call number 2 is right now.
I am on a long-term disability. I'm getting ready to go back to work. However, it looks like the position that I was employed at before, about 15 years, no longer exists. I wonder if they are obligated to put me into a different position, or most likely will I be getting a package? I'm 46.
It's more common than you think, right?
It is very common. You've been off on disability leave. You want to come back. Hey, that job doesn't exist anymore. So what does that mean? Well, the first thing we want to understand is it legitimate? Is it in fact true that that job doesn't exist? Or are they just trying to could get you to leave and retire, or they're making up excuses, because that could be a human rights violation. But giving the company the benefit of the doubt, maybe because you've been gone for a while, the company is restructured, that job doesn't exist anymore. Well, if there's another job for you, if it's a very different job, you may still be able to treat that as a constructive dismissal. The fact that there's no job doesn't mean your employer can just put you in any job. If there's a job that they can put you in that's similar, that you're comfortable with, no problem. You continue working, new job, you move on. But if it's a different job that you're not comfortable with, or maybe it's less pay, or not as senior, not as important, maybe one that you don't want to do anymore, or because you've done it years ago, that could be a constructive dismissal. That could be a termination, which means you're owed severance. So if you're coming back from disability leave, if your employer won't put you in your job, you got to take a pause and understand, why are they doing it? And is the new job they're offering you one that you want to accept? If you're not sure what to do, call me. And in terms of severance, let's take the information that we just got in that phone call, and let's plug that to pocketemploymentlawyer.ca, and let's see what this person would actually be owed. Even though, again, they haven't been terminated, but because it's a different job, that may be a termination situation. So let's say they're in a supervisory role, 15 years of service at the age of 46. Again, they haven't been terminated because the company says you can have this other job, but in reality, because it's likely a constructive dismissal, severance calculator, as part of pocketemploymentlawyer.ca, correctly assesses her as being owed 16 months pay. 16 months pay. That's a significant amount of money. And that's, by the way, John, how easy it is to use pocketemploymentlawyer.ca. Takes seconds, just as quickly as I did it right here. So check it out for yourself.
All right, coming up, the reality for real estate agents. We'll get to that. It is 1-855-821-5900 and employmentlawyer.ca. The Employment Law Show. Stick around. There's more coming right up.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to EMPLOYMENTLAWYER.ca.
Always check with the employment lawyer first at EMPLOYMENTLAWYER.ca.
And welcome back to the Employment Law Show, EMPLOYMENTLAWYER.ca. That is the place you go to catch the radio show. Phone call number 3 is right now.
I work as a real estate agent, so I'm an independent contractor in that regard. I also am part of a team where most of my business comes from, so I'm employed by the head member of the team. And what happened was I've been there for 3 years, and everything was good. I always was told I was doing a great job. I noticed that the team wasn't being as successful as it could have been. It was starting to go down a little bit. Then I made one little blunder, and I was sent a termination notice. I responded saying, how come this happened? And the letter I got back was, well, we'll bring you back, but instead of a set salary, you'll be paid by the hour, and it works out to be 25% of what I was making before.
I've always wondered about real estate agents because it seems like a gray area.
It is actually not even as gray as you think. I'll make it very simple. They're employees. And a lot of our viewers are going to be real estate agents or no real estate agents, and they're going to say, well, what are you talking about? I've been a real estate agent for 30 years. I know I'm an independent contractor. No, you're not. The fact that you've been treated as such or believe that you're such doesn't mean you are that in the eyes of the law. Most real estate agents work for one company, one broker. They take their leads from that broker. They don't have that much say in terms of where they work, how they work. They get all their income that way. So they're employees. At worst, they may be dependent contractors, but and likely they're employees. And I'm not saying that the real estate field is going to change the way it does things. It's going to do the way it is. But if challenged in court, they would likely be considered, these agents, to be employees. So this person, he's an employee, perhaps a dependent contractor, which is an in-between category between an independent contractor and an employee. So when he was let go, he was owed severance, even though, again, he is not, because he's not an independent contractor. So the fact that they offered him his job back at different terms, he doesn't have to accept it. If he wants to, he can. He's been terminated. He's owed compensation. So let's go to pocketemploymentlawyer.ca to find out how much he is owed. By the way, you can also go to pocketemploymentlawyer.ca to find out if you are really an employee or an independent contractor. So let's see how much this person is owed, this real estate agent. Very common, likely misclassified. So he's a real estate agent, 3 years of service. Let's assume he's 47 years old. He wasn't paid anything because he's an independent contractor, except if we see the pocketemploymentlawyer.ca, you see that on the screen, he's owed somewhere between 3 to 5 months' pay. 3 to 5 months' pay, depending on his income, that could easily be tens of thousands of dollars. So that's how easy it is to use. And for those out there that are real estate agents, probably the best time to deal with this contractor versus employee scenario is if you are let go.
Right.
If you are let go, the company or the brokerage company that you work for is going to assume they don't have to pay you anything because you're an independent contractor, but because you're not, you could have significant entitlements. So if you're a real estate agent that's been let go, if you know someone, your friend, your neighbor, and they've been let go, you got to tell them to reach out to me or go to pocketemploymentlawyer.ca. They may have some significant entitlements, John.
You mentioned it, pocketemploymentlawyer.ca, one more time before we wrap it up.
You know what? I'm going to leave here. We're going to wrap up the show in less than a minute, but I'm still going to be with you on pocketemploymentlawyer.ca. It's easy, it's free, it's anonymous. You couldn't pay for it if you tried. I wanted to give everyone the ability to have that legal analysis, that legal information with them at all time. Go to pocketemploymentlawyer.ca, find out if you're a contractor or an employee, find out how much severance you're owed if you're staring at that severance letter, find out if the company has cause, and many, many more things. It's groundbreaking. I'm very proud of it. Check it out for yourself, pocketemploymentlawyer.ca.
Done for another week. 1-855-821-5900 is the way to reach out by phone, and simply employmentlawyer.ca online as well. We'll catch you next time right here on the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.